of judgment. Item 1, WPC 2645/19.
This repetition is dismissed.
Item 2, review petition 54/2021 with IA Civil 1932/25.
This review petition is dismissed. Connected IA is also dismissed.
Division bench judgment. Delivery of judgment sitting singly. WPC Item 1, WPC 483/2017.
Challenge to the opinion fails and the petition is dismissed.
Item 2, delivery of judgment, writ appeal 28/2026.
This appeal fails and the same is dismissed.
Complaint.
Interim order passed on 13/10/25 stands revoked.
Declared.
So there's some mistake.
My lord.
There was an interim order.
There was no interim order in this appeal.
I made a wrong mention. Interim order passed in WPC 2608/19. This will be struck off. Striking of that
My lord.
part interim order.
My lord.
Right.
Yes.
Mention may be made for single bench.
My lord, in item number 3, my lord, in item number 3, there are 6 IAs pending. IA number 2162 of 2022, 2163, 2164, 2166, 2031, 2029 of 2022. All those IA has not come because there are 2 cases. One is dismissed for default.
We talked about this 2011 matter. We don't want to adjourn it.
My lord, in one case, my lord, it was dismissed for default.
Whatever way, but
In that
2007
case-
we don't want to keep it pending.
Then I may be called for, my lord.
Also, you give the list, we'll get it listed in.
Much.
May please.
Yes.
May please, Your Honor. With the consent of the other side, I'd like to mention item number 4 and 5. I'm suffering of severe throat infection, my lord, not in the position to speak.
Item number?
4 and 5.
My lord, I am appearing for the respondent. Full respondent in this order.
Otherwise, I would have done, my lord, but not convenient for me at all.
Pleasure to give you present. The P. Sharma, and as technical for the, and as, technical for the NS page two. That is well, with from chocolate. There is now list. On.
Except 25.
21, 2020.
But
Working Saturday. 21,
Saturday,
2020. Six.
much.
Much obliged.
Wait, please, sir. My lord, item number 8 of the daily list, my lord. My lord, I am not being able to contact the client in this matter. It's a old pending matter, my lord, and my lord, to my knowledge, the cause of action, I'll have to confirm whether it survives or not, my lord. I'm only
Just wait till
praying,
the matter is called because these are old, very old matter.
my lord. My lord, I'm only praying that it will be fixed on Tuesday next so that I can,
No,
Yes.
so this bench is not normally taking it up.
my lord,
This is a specially bench only for old
I
matter.
appreciate it.
Please let the matter reach,
All
then we'll see the
My
facts
lord.
then passed off.
Grateful, grateful.
May I please, Your Lordship? I'd like to mention item number 10 to 16, Lordship. I have circulated a adjournment slip also with the consent of the appellant.
2013 and
Yes,
12,
Lordship, but my difficulty is that Mr. M. Datta is handling these cases now,
So
but
we
he is
won't adjourn the matter unless we look at the record, because these are old pending records, we are specifically benches constituted only for that.
Lordship, but before also with him, he is in bereavement,
Let
Lordship.
it reach, we'll see the facts and then pass orders.
He is in bereavement, that's the
We
difficulty.
understand, we are not saying we'll definitely go ahead with the hearing,
Yes,
but unless we look at the record, we are not adjourning any.
Lordship.
Lordship, little accommodation required regarding item number 7, Lordship.
Same thing, we are not adjourning any matter without looking at the record.
Obliged.
Daily list item 1 for hearing RSS 67/10.
Dependent matter. And my lord, as per my instruction, my lord, out of court, both the parties have settled the matter, my lord. as per my instruction, but no such petition or anything is filed. Otherwise, my lord, appellant is the defendant, my lord, and suit was decreed by granting the perpetual injunction to not to construct, my lord. Against that, appeal preferred, appeal also dismissed, my lord. And my lord, substantial question of law, my lord, 7/1/2011 order, my lord. My lord, that order is not annexed in the alpha, you know, report I have not checked, my lord, but that is earlier suit, perhaps lordship, earlier suit, that is exhibit number, my lord. My lord, exhibit 1, my lord. Exhibit 1. So that is with regard to the different context, my lord. Obliged.
For hearing item 2, arbitration appeal 3/2011.
Also long pending appeal, under section 37.
Lordship, in this matter, I am appealing for respondent number 1. The respondent was represented by one Manvati Devi, who is a partner, and she has died long back in 2020. I could contact the grandson, and he is unaware of the entire facts of the matter. There are other partners in this firm, but as of now, if we proceed, then I think substitution has to be done. And before that, I need to take the status whether the firm exists and whether the partners are there in this firm or not. So the grandson has informed me that he requires certain time period to take the status on the matter.
With an apology, it's our fault. So it's our fault. Such long pending matters, we don't have the instruction from the client as well. But if there has been a death, then 2210A perhaps would come in, because so far as I'm concerned, I'm hearing it first time. Worship permits me, no, give respect. Since I get the information today, the clock starts. I write a registered letter, at least a month's time to get back to that. Then the presumption can be drawn and the case can be, a quietus can be given. Otherwise, if you don't come, the abatement would follow. I understand. Your Lordship is 21st. I understand. That's what. The clock starts from now. From right. With some order of possibility.
Response number two never appeared.
What if we say to take paper? The paper is right. No, why is it true? Why is it true? Obliged, Lordship. I need to communicate. My Lordship. It will come, but there's a catch. If his duty, whether it ends with the death information or the heirs of, it's a replay. Informs them. Absolutely. Huh. 7 months. Obliged, Lordship. I shall forward along with the certified copy of this order. I'll communicate. That will be better.
For hearing, item 6, MFA 5/2012.
Item three.
May I please, your lordship? Lordship, I'm on behalf of Miss S. Roy. Lordship, my senior is not well. She is out of station. Kindly give her a short date.
I am for Clement respondent, Lordship. I am for Clement respondent, Lordship.
Lordship may fix the date. 21/3. Obliged. Obliged.
Item 7, for hearing, MFA 25/2012.
Lordship, this is an injury case.
Sorry, sir, Lordship. 21/3 is the Eid al-Fitr. Eid,
So what is it?
21.
22nd?
Eid, whether it is the yes, sir. It is Eid al-Fitr.
Twenty-third or আমার বলতে চাচ্ছি 24th
4,
24th
4 will be Saturday.
okay. Lordship, we have taken in our grounds that the Lordship. Four 2004 Lordship. Four. Lordship. Lordship, as per annexure 1 in page number 14, para 7, where it was mentioned that claimant used to get his salary of rupees 1000 per month and rupees 90 per day. Lordship, it may be hard on some other days, but be a date fixed by your lordship, as I think your lordship, in presence of my senior, it may be good enough, lordship. Today he has some personal difficulty, lordship. Lordship, I will take instruction from him, lordship, for some time. It may be taken up after some time. Obliged.
Item 8 for hearing, FAO 17/2013.
My lord, premises the order dated 27/7/2018, my lord. The government was asked to obtain instructions whether the work has been completed, number one, and number two, whether the payment has been made, my lord. My lord, to my knowledge, my lord, the matter has become infructuous, but the government is yet to provide the instructions, my lord.
In our office record, lordship, one letter I have got after passing of this order, lordship. মানে এটাত হোৱা নাই, এটাত
Updated instructions to
আদাও
My lord, to my knowledge, my lord, the work has been completed, but the problem I'm facing is that, my lord, I have not been able to contact the client. Because it's such a old matter, my lord, and Honorable Justice Devashish Boga's matter, my lord, when he was on the other side. If I may submit, my lord, the government may be directed to obtain the updated instructions, my lord, whether the remaining payment has been made.
Yes, Lord.
Yes, my lord. It's a contractual matter, my lord, contractual dispute, my lord.
Outcoming of the titles of Lordship. It was not granted, Lord.
It was not granted, my lord, precisely why we have approached this honorable court, my lord. Yes, my lord.
Yes.
My lord. No, my lord. No, that I'll have to, I'm not able to contact the client, my lord. That is the difficulty I'm
Assessment of
facing.
2012 Lordship. 2012 Lordship.
My lord, we close it as infructuous, my lord. My lord. The suit was not stayed, my lord. The appeal was admitted, but the suit was not stayed. My lord. Online, there is no record, my lord. My lord. My lord. Yes, my lord.
Respondent number 3 to 6.
No, my lord.
Fair kind.
Grateful.
Climbing item 7.
Lordship, it may be heard. In presence of me only, Lordship. Service is complete, Lordship. Obliged.
Item 9. Arbitration Appeal 21/2013.
May I please, your lordship? This appeal is against the imposed judgment and order dated 21/11/2012 passed by the additional district judge Kamrup Manor by upholding the arbitral award and setting aside the claim number 8, if it concern the interest. So our claim was on claim number 3, 4, 5, 6, and 7. We have challenged these claims before the additional district court, but the planet court below uphold the arbitral award.
What is the, where is the finding with regard to the distance between the stocking yard, alternative stocking yard which you have provided
Yes,
with the original site envisaged in the agreement?
yes, my lord. Now, as per the agreement, the railway could not provided this path
No, we
zone.
understand that. That's why we are not asking you that. We are asking you what is the distance between the two site which you proposed from this site which you had agreed to.
Distance is not here, my lord. Only the staking yard was changed near Kulajan, was limited to 15,000 cubic meter only. The alternative staking yard,
According to your agreement,
yes,
there is a requirement to keep the man and materials ready.
yes, ma'am.
Now they say that you did not hand over the site and therefore from 15 March to 15th October, we are asking for the claim of idle charges of 50 trucks.
Yes, ma'am.
What is wrong in that? Your agreement says that,
My lord, yes,
your
my lord.
agreement says that these are to be kept ready always.
Yes, my lord.
Then
As per clause 17A, Roman 3 of the GCC, if the railways are delayed in handing over the staging yard, they are not liable to pay any compensation
did you
damages.
ask them to remove the machineries, the equipments and vehicles? Your
Yes.
agreement says keep them. You see, I use this pen where the ink finishes by
Thank you.
5 days. If I don't use it for 5 days, it evaporates. Now you tell me not to use it for 10 days and the ink evaporates.
This is correct, my lord.
Yeah.
As per clause, the contract is bound by this additional special condition of contract and GCC, my lord.
We understand, but you should have, you should have asked them to remove it. The clause could have been relaxed by you.
My lord, contract agreement was executed on the year 2002, and the second alternative site number 1 near Kulajan was handed over on 31/1/2003. So, my lord, only there is a 7 months delay, my lord. Contract agreement was executed on 24/10/2002, and due to the non-availability of the staking yard, railway further provided the alternative site number 1 near Kulajan, which was handed over to the contractor on 31/1/2003 after lapse of 7 months from the date of the agreement, my lord. So, as per additional special condition of this contract agreement is bound by the additional special condition of the contract and the general condition of the contract, my lord. As per additional
I'm
special,
asking you, what is wrong in that? You see, if you are reading that part of the order at page 30, that part says that the height which you gave would only accommodate 15,000 cubic meter quantity.
there are two disputes, my lord. One is the delay in providing staking yards. Another is the size of the boulders. As per agreement, they are required to give the boulders uh, 40 kg to 70 kg. But after receiving this boulder, when they measure this weight of the boulders, it found is less than 40 to 70 kg. Which was the response claim full payment.
Cost.
My lord,
That you reduce the cost of 15%.
15%, yes.
Then what is the grievance of your? You reduce the cost.
Yes,
Size
I
of
have
business
reduced
is
the cost.
small and you reduce the cost.
Actually, the date of completion was July of 2024, 2004. But due to the delay of stinging yard, the respondents completed the work in the December 2004 after granting extension. So under clause 17A3 of GCC, my lord, rail is not, if there is any delay by the railway, my lord, the contractor will not be entitled to claim any compensation or damage for any reason, but the railway can grant only extension. So railway granted extension till 2000, till December 2004.
this memo, Mr. Chakravarti, we don't find anything.
My lord,
Show that the finding of claim number 3 was incorrect.
my lord,
The award passed in respect of the claim number 3
hmm.
is incorrect. For that, we don't find any material.
In page number 25, my lord,
Yes,
the claim number 3, claim for the idle charges of site staff from 8/7/2002 to 31/1/2003. May I read, my lord? In my memo appeal annexer 1, page 25. Elaborately explain, the arbitrators elaborately explained why they are not entitled for this claim, my lord.
you have a copy of your evidence? Do you have a copy of your evidence with you?
No, my lord, I have only the evidence of the contract agreement and the award and the and various orders passed in this honorable court, my lord. The extra provisions of the clause 16(3)62(3)(d) of the general condition of the contract, extra copy of the provisions of the clause 17 of GCC and 17A(3) of GCC. These are this contract agreement is bound by this condition of the contract, my lord. This is my evidence. But as per claim, whatever I already stated, my lord, their delay was there. I am not considering the fact that to have provide this taking yard, that agreement was executed, my lord. But later on, due to the lapse of some problems, my lord, I have handed over the second side near Kulajan on 31/1/2003, only after 7 months. So, Minister, if the contract agreement is.
Yes, we're not answering our query. You see, in claim number 3,
Page
there's a
number,
finding, specific finding.
page
You
number,
see, page number, you find out claim number 3, I don't.
man, I am
think
going
I
to
had-
award, man.
Wherever it is, claim number 3, you see, you will find the finding is given. And in that finding, there are reasons assigned. And one of the reasons is that it was the case of extraction of boulder. It could have only be done during a non-rainy season. And therefore, they collected the materials and kept it stacked. Now you have to show us that it is a wrong finding. That's number one. Second is, you will find that there is a dispute between North Bank and South Bank. They said that erroneously stacked there, but for that you reduce the price by 15%. Third thing, if you will read what you call that, arbitral award,
Yes, my lord.
come to page 18. It starts from 17, come to 18.
Yes, my lord.
Please read all this,
Brief history of the case,
all
ma'am.
these pages till page number 20. You will not find anywhere that you have led any evidence.
Yes, my lord.
If you have not led any evidence, please tell us in the High Court, how can you ask us to rely on the terms and conditions of the GCC to negate the claim, which you did not produce either before the arbitrator, nor produced before the district judge?
So, my lord, my lord, evidence is so much concerned when I have handed over the taking award.
We don't know. There's nothing on record to show that you
Yes,
have
my
led the
lord.
evidence.
So, my lord, short time may be granted, my lord. I will ask the I of the instruction from the
But it's
lady.
not during the award. How
Not
can you
in the
improve
award.
it?
Yes, my lord.
How can you improve it? It's not even your case. You look at your memo OT. In a memo appeal also, you don't say that the evidence was overlooked. You only say that the clause of the agreement, but you don't say that this clause was produced. Look at the grounds at page 3 onwards. I
Ma-
cannot find it, but
My lord, yes, my lord.
you'll have to excuse me if I have omitted reading something because we don't read it every word by word, we don't read. We take a general overview. Now, in a cursory look in your ground, we don't find that there anything on the top to show that evidence was there.
Only statement is there, my lord. No documentary evidence is there, my lord.
But then you can come to your this documents.
My lord, in my grounds, ground number 5, 6, my lord. Only I made this in respect of the claim number 3, 4, 5, and 6, as well as claim number 8, that as per schedule item number 1 of the contract agreement, the supply boulder was the obligation of the contractor respondent with all leads, lift, and distance, including crossing of the channels, nalas, etc. In providing the connected roads leading to the staking award was not the obligation of the railways, as per contract agreement, my lord. So, my lord, however, owing to these difficulties, the contractor respondent was given an alternative adequate site near Kulajan for supply staking the boulders, even during the monsoon and flood period on the respondent's request. And the said staking award was free from encumbrances and always available to expedite the progress. Moreover, the availability of the staking was limited to the respondent by various letters as well as by verbal instruction. Second site was provided to the respondents on their request, manner.
You understand, but you did provide.
Mm.
Now tell me, I don't have much experience in railways, but please assume that I am traveling from Gauhati to the what you call next railway station of Digaru.
Yes.
Now, in the meanwhile, if you have to keep certain items stacked, can we presume that the items will be stacked on the railway track? Or it will be stacked on a plain land? You want the contractors to stack everything in the railway property, or do you want the matters to the stacking of materials at the land provided by you? Now, in this passage from here to Digaru, you show me a land which is otherwise available for a contractor to stack something. Just because he has a contract, he cannot come into your land and stacking goods.
Yes. This is obligation of the contractor where they will stake the materials, my lord.
You have not even proved that.
Yes, my lord. In my ground number 5, my lord.
Don't say about the grounds. Look at the fittings. The initial fittings, where did you say that? That it was the responsibility, and if it is their responsibility, why did you give it? Second land, alternative land, why did you give it? Why you say alternative land?
It is on the request of the respondents, my lord.
Alternative land you also give
Yes, my lord.
on request.
On request.
Very good.
Because they are not getting any site, any staking yard to stake their materials, my lord. Then they intimated the railway provided this site on their request, my lord.
Where is it? Show us.
Claim number 1, award at page 25, my lord. Claim number 3, claim for idle charges of the site staff from 2002 to 31/1/2003. The tender was accepted on 8/7/2002 and the site was handed over on 31/1/2003.
After a lapse of
7 months. After a lapse of 162 days.
therefore,
The arbitral tribunal has gone in detail of the site availability and found that the approach road to the original staking was not ready till
here,
December 2003.
Mr. Chakravarti, you start writing like this. After award of the contract, the respondent started work and asked for delivery of the site for packing. The holders at zone number 2. But the railway failed to, we are reading synopsis. But the railway failed to hand over the site because of the fact that the approach road to the site was not yet ready.
Yes,
And on request of the contractor, an alternative site, that means it was your responsibility to give the first site. This is an admission of fact.
yes, ma'am.
Then how can you result from your
No,
admission?
railway already admitted that they are handicapped to hand over this site, my lord, as per the contract agreement. Then on the request of this respondent, they have handed over the second site.
Realize it from your officers who have entered into this contract.
Yes, madam.
You want an order from us to recover money from them. We'll have to record your statement and give you that award. Recover money from the officers who have made this
Yes, madam.
drafting. Because then you say, then you turn around and make a new statement now. In your synopsis, then you say, contractor deployed men and machineries, stakeholders, and in the meantime, the first site was ready. And the first truckload of holders could reach site only on 8/3/2004. That means he stacks 15,000 cubic meter of materials at site number 2. Then you said site number 1 is also complete. Then he comes and stacks 10,000 cubic meter of boulders there. And you still don't want to pay compensation.
In my affidavit, my lord, I filed another affidavit also by annexing my contract agreement. Then I have to go through. As per the condition of the contract, the contract agreement, my lord. In additional special condition of the contract, within contract agreement, the work shall be executed in conformity with the tender document, such as the general and standard special condition of the
Which page?
contract.
You are
Page, my lord, page 17, my lord, in my affidavit, my lord. Additional affidavit, not in a memo appeal, my lord. I filed an affidavit, my lord, by annexing this contract agreement, my lord. In affidavit, page 17, clause 2.2.1, my lord. The work shall be
Just
executed.
stop.
I'm appearing on behalf of Mr. K.L. Gupta. He is indisposed now. He has requested me to, if the matter may be passed over for the time being. If the matter may be passed over for time being, he'll be coming and joining the court after some time. He's in the midst of another argument.
We are hearing her in the meantime.
Obligement. If I may seek your lordship's account handle, obligement.
Mrs. Chakravarti, we are refused to look at your additional affidavit.
Yes, my lord.
We refuse to look into it and read it. This is a practice we will not allow. You give only few papers out of the contract agreement. You have saved a lot of money in not photocopying the entire agreement. You can't give us piecemeal documents to read.
My lord, here, my lord, in annexer 5 is the actual contract agreement, my lord.
It is the
Annexer.
actual agreement.
My lord, this is the contract agreement executed between
Is
the
it
parties.
the complete agreement? Tell us.
Yes, yes, my lord.
You take a very big risk.
This is a complete agreement, my lord.
This is complete agreement.
Yes, my lord.
We'll call for the original one. And we'll make it clear that if it is wrong, then you will be proceeded with for contempt.
My lord, as what about the document I have received from the railway, my lord?
I don't know. We are taking it very seriously. You want to look into it? Come to lecture 5, page 14. This is page number 1.
Page 14, my lord.
Correct, according to you.
Yes, 14 is
This
the,
is page number 2.
yes, my lord, annexer 5.
Correct.
Yes, contract agreement of the works.
It is okay.
Yes, my lord.
You are saying it, we are accepting it. Now, second is page number 3.
Page number
It-
3. This is the schedule of the items, works and appropriate quantities.
Correct.
Then, my lord,
Then comes page number 8.
8.
So
It is the cross it.
we don't know. We are showing
No,
you the
no,
page
they-
numbers.
Yeah. Then, my lord, I have to bring the original
No,
contract.
don't
agreement.
bring it. Now we'll not take it. We take an exception to it.
No, it is whatever I given to me, my lord, I have annexed it here, my lord.
We'll record this and dismiss the matter.
Yes, my lord.
We'll record this and dismiss the matter. This is not how we produce records.
No, it is already cancelled by the railway, my lord. They already, their signature is there, my lord. The chief engineer,
All the signatures, I personally don't know these people.
I don't,
Don't tell me that this is the signature. We don't know about the signatures. I know the NFLW personnel, don't know the contractor.
I don't know to why
Practice
they
that
have
the document
cancelled it, my
produces
lord.
income.
I also don't know, my lord.
We take strong exception. After that, page 7, then page 9, then page 10, then page 11, then
Yeah.
12, 13, 14, 15, 16,
No, 13 is,
17, 18, 19. So the meantime, the pages are missing.
this contract agreement they have given to me, my lord.
We don't know. We take a strong exception to incomplete document produced.
To page 7, my lord. Page 7, they have cancelled. 88 is there.
Then again, you produce the documents.
Only
You
one,
produce only incomplete GCC you are producing.
my lord.
The incomplete special conditions of contract you are producing.
Additional special condition of contract
of
is
the-
in this
out of the
agreement, my lord,
PCB
in
you
contract
start-
agreement. It is in contract agreement, my lord, page, my page 17, internal page 8. The, my lord, here the clause 2.2.1.
Page 57, you give us general conditions of contract. You don't give us complete contract, give us incomplete. Then next,
Only, I have annexed here the clauses, my lord.
no. That's not how we read the documents. And there's no statement or note that these were produced before you come to this affidavit, first part of that affidavit. In the affidavit, you have not said that this was a part, this was all there before the arbitrator. There is a statement that all these were before the arbitrator.
What is passed on the
We are asking a very simple question. You are producing some affidavit here. Annexes to that affidavit was before the arbitrator. Please show us that statement. Where is that statement that these were all before the arbitrator? Show us that statement. As simple as that. And supplementary question to you is, can we look into a document which is not there before the arbitrator? In the meantime, I'll take a short break and come back. Close these two please.
My lord, in the brief facts of the case, arbitrator already mentioned here that the construction of the bogeybill, huge quantity of boulders are required to be
I'm
First
posing
and
you
so-
two questions.
Yes, my lord.
I'm a bit hard of hearing other things when I put a question. Other things is very hard to accept. Please answer the two queries and then we'll hear you.
I'm sorry, my lord.
Yes. You have answers to both the queries.
My lord.
Answers to both the queries.
Yes, my lord. Yes, my lord.
What is your answer? What is your answer to the queries put by us?
My lord, as per the contract agreement, award has passed, my lord. So
We
we
are
are,
not on that. We are asking you a specific question.
hmm,
Is there any statement made in this affidavit that all these documents now produced were presented before the arbitrator?
yes, my lord. There,
Where is that? To us.
there is not here, my lord.
It's not here. You see, you are pushing us to a corner where we don't have any alternative but to arrive at a very inconvenient conclusion. This affidavit is sworn by you.
Yes, my lord.
That means the officers of the NF Railway doesn't take the responsibility. You take the responsibility upon yourself.
Yes, my lord. So, my lord,
You are taking responsibility. It's your affidavit.
so I'm not pressing this affidavit, my lord. I maybe, yeah,
Then we have no alternative but to dismiss your appeal. There's no wrong then.
as your lordship, please, my lord.
Let the other side come. Maybe he supports you. We don't know. After some time, let the other side come.
Obliged, sir.
He may support you.
I don't know, my lord. How will he support me?
I don't know.
He may not support me because he is in favor of the respondents, my lord. I am in favor of the appellate.
Let him come because he made a request.
That is up to lordship, bring fit and proper lordship. Sorry.
Item 10 to item 16.
May I please, Your Lord? As I mentioned, I have made a request for adjournment. Mr. M. Datta is in bereavement and out of, Mr. M. Datta, he is handling this
Counsel
case.
for the, appearing for the
No,
owner.
okay, but these are old matters. Especially
I'm ready.
you
Otherwise, I'm ready.
look at the No, we'll adjourn it, but not without looking at the record.
Yes, ma'am. May I put the brief facts, my lord, what are
No, we are not hearing it.
my lord,
We just want to look at the record.
my lord,
If there are any defects, we'll look into it.
my lord.
If the records have not come or something, then we can always. You're the appellant.
Yes, ma'am.
Your appeal would abate. Look at there's
We
an
have-
office, there's an office note, you have not taken steps on 2A and 2B. The person had died.
My lord, substitution, after the substitution was allowed,
We don't.
my lord, I'll just have to. I'm sorry, my lord, if that has happened, because I had instructed immediately on substitution.
There's an, that's why we don't want to adjourn those matters
My lord.
without looking at the record.
Look, Proxy may kindly see the order taking 782,000, judicial order. In fact, well, since they had represented the substituted legal heirs, they had accepted the notice and there is an order, judicial order in the past.
That's why.
Maybe I'm wrong, my lord, but judicial order.
I will check the record.
My lord.
That's why
My-
before adjourning the matter,
My-
I have to look into the record.
Normally, this type of mistake doesn't happen, my lord, but maybe due to oversight it had happened.
You're right.
At the time, we have to take the input and keep it in the file. It's just usual for them. Lord, before Rocky,
Johnson matter, and just a simple prayer, my lord. This is a case where once the hearing was proceeded with, and later on when I found that the notices were not, so I pointed out to the court, and again it reverted back. So it's a double sunny type of a case where again and again, my lord, the matters are not, my lord, taken up. So can I pray for a fixed date, my lord?
No, we're giving the 19.3.
My lord, 19th will be inconvenient. I'll be out of station, my lord. Can it be 4/9, my lord? Sorry, 4/4, my lord. I'll be going to Delhi for a short break. 4/4, my lord. Yes, ma'am.
What says that presented? The learned counsel for the respondent, respondent. Submit that this time the learned counsel appealing for the, holding the brief for respondent, the private respondent is in bereavement. Accordingly, matters can take one day. This matter is very common. 4/4/2020.
Obliged.
Massively.
The small things which at times we don't take notice and then what do you call it? The time of hearing these defects suddenly come to notice. That's why I have a habit of.
No, the lordship is absolutely correct, my lord. My fault that time when we had proceeded with the hearing, I suddenly saw the records and I found that the respondent is expired. So I had to make a prayer and till then, my lord,
At least we are clear on one part.
right, I'm obliged.
Obliged.
Item 3 for hearing with production list item 1.
My lord, there are two appeals actually. Test appeal 5 and another is 11, my lord. In the 5, it was dismissed for default. So I have filed the application for restoration along with delay condonation. And in both the appeal, my lord, the respondent, executor of the will died. So I have filed substitution along with the condonation application, my lord. So that is why 6
Can't be substituted. Can it be substituted?
by the beneficiaries actually. I filed application for substitution of the beneficiaries in place of executor. Actually, abatement does not come, but I filed an application for respondent beneficiaries respondents as substituted by the executor.
Nobody is appearing for the respondent?
Since died, my lord, executor, he was earlier appear on behalf of executor. Now-
All the earlier set of counsel were all for executor.
Executor. So at this stage, only notice will be issued in the IA, my lord.
IA 2162. So notice on this interlocutory application.
2162 is for
Why did you keep it pending for so long? This filed in 2022. You never made a mention for getting it listed. So now you'll have to also explain that. Title 19/7/2022 for condemnation of delay of 463 days beyond the period of limitation in filing the restoration application of the test appeal 5 of 2011 by setting aside the order dated 26/3/2019. Next. The applicants shall take steps within 2 days, 2 working days for service of notice on their by speed post with the the cost for the applicants are liberty to collect the postal receipt number and to submit postal tax report prior to the next day. Once it's 029.
2029.
The application. That is business first. He says, "Okay, what should we talk about?" Notice on this application, filed under section 5 of the Limitation Act. Application filed on 22/6/2022 under section 5 of the Limitation Act for following the delay of 23 days beyond the period of limitation. In filing application under order 22 rule 4 CPC for subscription of the legal affairs of.
My lord, may some mistake in submission, my lord. Earlier, beneficiaries died, Shivram Rava was substituted. Then Shivram Rava died. Now his son and wife and minor.
Subscription of the
Paragraph
representatives of the deceased respondent who had died on 14/7/2021. Submission of it. Then will be only in this book. And in test appeal, give a returnable date after progress, give a date. Returnable of this.
Will take steps only on 2 IS, no?
Yes,
Yes.
in the main test, appeal will say. For this SK post file counsel for the applicant. Next one. As notice has been issued in IS Civil 2162 of 2022 and 2029 of 2022. This matter can take long. List also is. When it will be connected IS.
Much of.
What is this test appeal file? This is dismissed.
That is 2162, your lordship, pass order for restoration of festival.
Okay. But Mrs. U. Chakravarti ran counsel for the appellant. Also have C.K.S. Barwa run counsel for the respondent. Filing this appeal under section 37 of the Arbitration and Conciliation Act of 1996. The appellant has assailed the order dated 21/12/2012, passed by the learned additional district judge number 2, Cambro Metro of Gauhati, in Miss within bracket RPRP, bracket case number 14 of 2025, by which the arbitral award dated 26/4/2005 passed by a two-member arbitral tribunal or three-member tribunal. Tribunal is 3 persons.
Yes, my lord.
Or three-member tribunal. Full stop. Tribunal. Next paragraph. The arbitral tribunal was appointed to arbitrate over the dispute between the respondent and the and a railway. In terms of letter dated 14/10/2004, issued by the general manager within bracket construction, bracket closed, NF Railway, Maligaon. Next. Brief case of the appellant is that for the purpose of construction of Bogeyville Bridge, huge quantity of boulders were required for the purpose of river training works, TRINING, training works. No, don't say that. Training works, training work, as stated in the arbitral award, however, from the contents of the contract agreement number, capital CON oblique Bogeyville, BOGIBWL, oblique 15 dated 24/10/2002, the name of the works is stated as invert comma start quarrying QUARRYING, quarrying and supplying 75,000 cubic meter CUN within bracket approx bracket closed man size man size river boulder weighing between 40 kg to 70 kg and stacking at zone dash 2, numerical 2, at stacking yard at Bogeyville Bridge site near Dhemaji on north bank of Brahmaputra River. To stop, inverted comma closed. To the learned arbitrators, the work component were of 2 items in the schedule, and the item and item number 1 was the main item comprising of supply of holders, which accounted for 99% of the contract agreement value. And the second was for the purpose of tracking of the holders. Next, after award of the contract dated 8/7/2002, the respondent started the work and requested for the stacking yard at zone number 2, as indicated in the map attached with the contract agreement. However, the had failed to hand over the site, mainly because the approach road was not ready. Accordingly, at the insistence of the respondent, an alternative site number 1 near Kulajan, KELAJAN, was handed over during the last week of January 2003, about a lapse of 7 months. The projected claim of the respondent was that the alternative site number 1 could accommodate only 15,000 cubic meters quantity, and the respondent and the appellants could not hand over the site and after completing supply of 15,000 cubic meters of holders, started asking for the additional site, and the second alternative site was handed over on 27/1/2004. It's projected that the respondent had deployed men in machinery and after having stacked 15,000 cubic meter boulder in April 2003, stacked further amount of 10,000 cubic meter boulder in the same stacking yard by May 2003. And accordingly, it's projected that a total amount of 25,000 cubic meter supply was made in the alternative stacking yard number 1 by March 2003. Therefore, the claim, among others, was for delay in handing over the stacking yard, and therefore the responding claim idling charges in respect of men and machinery before. The second dispute raised by the respondent with regard to this, the supply of item number 1 is that as per the schedule number 1, the supply of boulders from nominated river quarries QERRIA of size 20 to 30 centimeter and 40 to 70 kg in weight of power, as per field report. There were no boulders which are in the range of 20 to 30 centimeter that are weighing even 40 kg and not to speak of 40 to 70 kg in weight. And accordingly, boulders which are weighing less than 40 kg were supplied, and the appellant had paid reduced rate of 15% by invoking clause 8.0 of the contract agreement. The respondent had claimed full payment for all the boulders which are measuring 20 to 30 centimeters. The arbitrary tribunal as against claim number 1 regarding payment due against arbitrarily deducted voids VOIPS, arrived at the conclusion that the respondents had proved beyond doubt that they were entitled to receive payment based on the measurement of gross quantity, and accordingly it was directed that the appellant should release all payments deducted on this count. Next one. In respect of claim number 2, which relates to reimbursement of the wrongly deducted amount of supply of undersized boulders, took note of the ambition made by the appellant in its parawise reply that owing to the circumstances that no boulders of size up to 30 centimeter was weighing more than 40 kg in weight. Boulders of the size of more than 30 centimeter were weighing 40 to 70 kg. Accepted the supplies, but at a reduced rate of 55% of the accepted rate. Arrived with the conclusion that the respondent was entitled to reimbursement of full amount, which has been deducted in the name of undersides. In respect of claim number 3, relating to idle charges of site staff from 8/7/2002 to 31/1/2003. The learned tribunal consideration of the materials placed before it the the idle charges should be paid from 16/10/2002 year to 31/1/2003, i.e., for 108 days for it for serial with engineer site accountant 1, page 90, 1, 2, 3, 4, 7, total amount 2,93,550. As regards claim number 4, regarding claim of idle charges of site staff from 1/6/2003 to 31/12/2003. The arbitral tribunal note of the fact that the original stack area had become motorable in December 2003, and thereafter it became available for tracking of boulders. directed payment of idle charges from 15/10/2003 to 31/12/2003 within brackets 77 days. But 108 days. You then go section 1 to 108 days. Secondly, 77 days for the following staff. Each 21. Amounting to rupees 3,06,975. In respect of claim number 5, relating to claim of idle charges of machineries and vehicles from 8/7/2002 to 31/12/2003, the learned tribunal directed idle charges to be paid from 16/10/2002 to 31/1/2003 for 108 days for the following machinery, page 21. Respect of claim number 6, relating to idle charges of machineries and vehicles from 1/6/2003 to 31/12/2003. The learned tribunal directed payment of idle charges for the period for the period from 16/10/2003 to 31/12/2003 for 77 days for the following machinery. 21. Claim number 7. In respect of claim number 7, and for underutilization of queries at Arunachal Pradesh, the Dalit Tribunal arrived at the conclusion that the underutilized amount was rupees 10 lakh, which was a direct loss of the respondent, and accordingly the learned arbitral tribunal directed that the respondent should reimburse sum of rupees 10 lakh to the respondent. In respect of claim number 8, 9 and 10, as the claims are not referred to the arbitral tribunal by the appointing authority, those claims were held to be beyond their jurisdiction and therefore not considered. Accordingly, in a summary of the award declared, the learned tribunal, by referring to all the 10 head of claims amounting to rupees 5, 32, 31, 181, held that declared the award the extent of rupees 1, 53, 73, 018, which is summarized as under page 24. Was further directed that the respondent, that the appellant was to arrange payment to be made within 40 days from the date of declaration of the award, failing which the respondent would be entitled to interest at the rate of 10% per annum. We continue our post lunch. Next para. Agreed by the arbitral award dated 26/4/2005, the appellant preferred an application under section 34 of the Arbitration and Conciliation Act, 1996 for setting aside a part of the award in respect of claim numbers 3 to 7, amongst others, on the ground that the said part of the award is not tenable and maintainable as the general conditions, as clause number 17 capital A within bracket small Roman 3 bracket of the general conditions of the contract forbid any compensation and or damages for whatsoever reason if railway fails in providing site or delay, etc. And further by stating that the arbitrators had failed to adhere to the said clause, and accordingly the arbitral award dealt with disputes not contemplated or not falling within the terms of the submission to arbitration, or that the decision contains on matters beyond the scope of submission to arbitration. Next. The learned additional district judge number 2, Kamrup Metro, Gauhati, by an order dated 21/12/2012, refer to the 10 issues which arose in the proceedings before the arbitral tribunal, and specifically to note of clause 17A within bracket 13 of the general conditions of contract, which according to the appellant forbids payment of compensation the said learned court on revisiting the decision of the learned tribunal affirm the finding of the learned tribunal as regards the non-availability of man-sized river boulders of 20 to 30 centimeter to have weight between 40 to 70 kg. And therefore arrived at the conclusion that it was practically impossible for the contractor to fulfill the criteria set out by the appellant at the time of the established, and at the same time, while collecting and supplying boulders as per item number 1 of the schedule of items, and specifically took note of reducing of the payment by 85% of the accepted rates as per clause 8 of the contract agreement, 8.0 of the contract agreement, for supplying underweight boulders accordingly, agreeing with the view taken by the learned arbitrator that the range of size has made the schedule defective and non-workable, and therefore found the respondent to be entitled the amount which was deducted from the boulders, it regarded as undersized, and held that there was no scope to set aside the arbitral award on this account. The said learned court, in respect of claim number 3 and 4, concurred with the finding of the learned arbitral tribunal on idle charges for staff and machineries for the period of 108 days and 77 days respectively, and also refer to the finding that after first alternative stacking yard accommodate only 15,000 cubic meters of boulder, it was fully utilized. The respondent has started asking for delivery of additional site for stacking of boulders, and the appellant had failed to provide the additional site. Therefore, affirm the finding of the learned arbitral tribunal as correct, while awarding idle charges for the site, staff, as well as machineries and equipment and vehicles for the set to period of 108 days and 77 days respectively. And accordingly, affirmed award in respect of claim numbers 3 to 6. In respect of the underutilization of the query at queries QA other ideal queries at Karnataka Pradesh. The set minute code appreciation of the facts and evidence affirms the finding of the learned arbiter in awarding 10 lakh interest cost for underutilization of the query cited Karnataka Pradesh. In respect of claim at serial number 8 towards claim of interest of the current court found the decision of the arbitrator to be erroneous on the ground that the arbitral tribunal had denied to adjudicate upon the claim of the contractor on this account. It awarded interest and therefore finding in respect of claim number 8 was set aside, and the decision of the arbitral tribunal so far as it related to the claim of the respondent containing numbers 1 to 7, 9 and 10 was where next step. The Donald special senior special counsel for the appellant had referred to the memo appeal, and it was submitted that the arbitral award warranted interference of this court as the learned arbitral tribunal failed to interpret and examine the contract agreement and the general conditions of contract of 1998, which is binding on the appellant as well as the respondent, and awarded compensation on account of delay in providing of the site stack holders in this regard by referring to clause 17 capital A within bracket 3. It's submitted that it is clearly mentioned that the contractor will not be entitled for compensation for any delay in handing over the land, etc. It's submitted that the supply of boulder was the obligation of the respondent, and there was no agreement with the appellant to provide land for stacking of the boulders. So it is submitted that as per her instructions, it was only because of request made by the respondent that the land was provided by the appellant prospecting of the holder. Therefore, as that part of the providing of land not covered by the contract, is not liable to be compensated by the appellants to the respondent only on account of delay in providing site. Mrs. Chakravarti, any point we left out?
My lord, it's so far interest is concerned under claim number 8, my lord. So arbitrator granted nil award. Then the respondent preferred the application misapplication case number 17 of 2005 for selling this award on the ground of interest. And that was set aside by the additional district judge number 2. So we have taken this ground also here that we are not liable to make payment of interest under clause 16(3). And
So that interest, there is no cross appeal here.
there's a yes, my lord, section misapplication case number 17 of 2015. In my affidavit already I annexed this.
It has been set aside.
Yeah, my lord, yes.
Is there cross appeal here?
Not here, cross
Then
appeal.
it's already gone.
Along with the clause 17A of Roman 3 of the GCC, there is another clause 2.2.1 of the additional special condition of the contract.
It is also submitted that clause 17 within bracket A within bracket small 3 of the GCC general conditions of contract from 1998 was made a part of the agreement by virtue of clause 2.2.1 of the additional
Special condition of
special conditions of the
the
contract.
contract.
Next. It may be stated that the present appeal was filed on 15/3/2013 and pursuant to the amendment being allowed, the amended memo appeal was filed on 28/5/2015. It is noticed from the award of the arbitral tribunal dated 26/4/2005 that it contains no mention about the nature of pleading made before the said learned tribunal by the appellate. Full stop. Therefore, it is not known. Moreover, the nature of pleadings made before the arbitral tribunal is not made up part of the memo appeal. Stop. Therefore, comma, from the materials available on record, comma, it cannot be said that the the clause (17)(a)(3) or clause 2.2.1 was specifically urged by the appellant for the arbitral tribunal. It is not one of the grounds of the present appeal that the learned arbitral tribunal failed to take notice of clauses 17(a)(3), despite the same being produced before the said learned tribunal, supported by pleadings. The court takes notice of the fact that by filing an affidavit on 23/7/2019, the use of words in respect of the respondent and copy of the general conditions of contract been annexed. The pages of the contract agreement and all the and the entire general conditions of contract, standard special conditions of contract, prepared by the engineering department of the NF Railway has not been produced. The court is disinclined to accept an incomplete document as a reliable document in the absence of a statement that the agreement, contract agreement of general conditions of contract and special conditions of contract were produced before the arbitral tribunal. Okay, also, full stop. Court takes notice of that the affidavit has been sworn and filed by the special senior railway counsel. And for the reasons stated above, on the same is not considered and rejected. This is the learned special senior standing counsel for the NF Railway permitted to withdraw this affidavit, which was here is allowed. Next part. Insofar as two broad claims are concerned, firstly, with regard to the non-providing of the site for storing the boulders, as already stated above, as per the contract agreement, the nomenclature of the work is as follows. Yes, acquiring and supply of reservoir so and so Brahmaputra River. Full stop. Therefore, it is evident from the contract agreement itself that the place of stacking is stacking of the materials is contained in the description of the agreement, with stacking yard at zone number 2 at Bogeybill Bridge site near Dhemaji on north bank of river Brahmaputra. Therefore, if providing of a site is inherent in the contract agreement itself, the arbitral award has rightly directed compensation for compensation to be made for idle charges for men and machinery when the earmarked site for stacking at zone 2 at the stacking yard of Bogeyville Bridge was not made available to the appellant, to the respondent. Full stop. In this case, the providing of site was not an incidental accompaniment to the agreement. Rather, comma, it's an essential part of the contract. Full stop. It is not the projected case of the appellant that the respondents were excused from adherence to the contract of keeping men and machinery available at site. Therefore, comma, it is not open to the appellants to make a default and then claim that they would not compensate. If there was a delay in providing of the site, comma, the NF Railway could have the NF Railway of the appellants could have excused the performance of that part of the contract, which required the respondent to keep the men and machinery available at site. That's covered. The appellant cannot be allowed to take advantage of their own default. Stop. Next paragraph, with regard to the weight of the holders of size of 30 centimeter and from 20 to 30 centimeter and 40 to 70 kg weight. The arbitral tribunal had relied on a field survey where it is found that no holder measuring 30 centimeter is also weighing even 40 kg. So 30 centimeter is the maximum size of the required boulder, and the minimum weight is prescribed as 40 kg. Thus, comma, the arbitral tribunal had held that both the criteria cannot be fulfilled simultaneously from the holders queried from the queries nominated by the respondent. This part of the finding has not been dislodged by the appellant by giving evidence so that at the nominated query average boulder of 20 to 30 centimeter would having weight of 40 kg. Accordingly, the arbitral tribunal arrived at the finding that the government organization is not supposed to prepare such schedule of work, which is practically not possible to execute. The finding by the Bennett arbitral tribunal directing that the deducted amount paid to the respondent cannot be forfeited. There's nothing on record to show that in respect of any of the claims from claim serial number 1 due to 7 would be demolished by the appellants by reducing within a reducible evidence before the arbitral tribunal, comma, in the considered opinion of the court, comma, no ground has been made out by the appellants for interference with the arbitral award. Next, it is further stated that no clause 17A with bracket 3 of the general conditions of contract can be said to be a part of agreement by virtue of clause 2.2.1 of the special conditions of contract. But the appellant was required to read and put the same. Even before this court, the pleadings was made before the arbitral tribunal, and the nature of evidence made before the arbitral tribunal is not available. To dispel, to dislodge the arbitral award by showing that the under arbitral award that the arbitral tribunal had committed perversity in appreciation of the pleadings and evidence. Next, 40 comma. Court does not find any merit in the plea. 40 stands. Next. So the parties are left to bear the cost.
Okay, yeah.
This Chakravarti, take care. These affidavits will land you into some.
Yes, yes, sir.
Since you made
I
that
could take care.
statement, since you made the statement, we are not taking it seriously.
Oblige your lordship. Oblige your.
Uh,
In future, I'll take care of it.
Please take care.
Yes.
We know you are, that's why we are not taking an offense of it, but we also have some limitations.
Yes, my lord. Oblige your lordship.